Moving on to the next portion of our rules, we are going to be discussing transactions and communications with persons that are not our clients. This portion of the rules makes up 2 to 8% of your total NPRE exam. So the first rule that I want to discuss here is all about communications with represented persons. So here the rule says that in representation of a client, a lawyer shall not communicate about the subject of the representation with the person that the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or court order. If a lawyer learns that a person that they are talking to is represented by a lawyer, the lawyer must immediately terminate that communication with the person. So let's just stop there. This means if you are representing plaintiff in a matter, you shall not talk to defendant if defendant has an attorney. Instead, you should simply be talking to the defendant's attorney. This is true even if the defendant regularly calls your office and wants to speak with you directly. You should not do that unless you have consent to speak to them directly from their attorney or from a court order. If you are, say, chatting with someone and you come to find out that they have an attorney, you need to make sure that you stop that communication and then pick up where you left off with their attorney. Because again, if someone is represented, you should be speaking to their attorney. I mean, after all, that's why they've hired the attorney in the matter, so you should be speaking to them about it. The other thing I'd like to point out about this rule is that this rule speaks specifically as to the matter of the representation. So the rule specifically says that this rule does not prohibit communication with a represented person or an employee or an agent of such person concerning matters outside of the representation. So for instance, if you're walking into court and the client for the opposing party is walking in behind you and you hold the door open and you say, "Good morning," or "Isn't it a beautiful day?" or something like that. Assuming that those two things have nothing to do with the legal matter at hand, you can actually do that. Why? Because you're simply not supposed to speak to someone regarding the representation if they have an attorney. So you can speak to them about other things outside of that matter in which the litigation or the legal issue is involving, but you should not be talking to them about the legal issue. As this rule applies to organizations, when we say organizations, it might be helpful for you to think about this in the context of a corporation, because a corporation is not a person, but it's obviously ran by people. So let's kind of think about it in that framework. So in regards to this rule, in the case of a represented organization or corporation, if that's easier for you, this rule prohibits communications with a constituent of that organization who supervises, directs, or regularly consults with the organization's lawyer in that matter. So let's say you are suing a corporation. You should not be speaking directly to, say, the CEO or the president, because it's likely that the CEO and the president communicate directly with the lawyer or directs the lawyer that is representing the corporation. It then goes on to say that you should also not speak directly to anyone who has the authority to obligate the organization with respect to that matter. So oftentimes this means anyone higher up in an organization or corporation can likely obligate that corporation or organization. So you should probably not speak to them and instead just speak to that organization's attorney. And then lastly, this rule says that you should not talk to anyone whose actions or omissions in connection with this matter may be imputed to the organization for purposes of civil or criminal liability. So again, anyone, depending on the facts, who might be able to do something that would involve some sort of liability on behalf of that corporation or organization, you should not speak to them directly. Instead, just speak to that organization's attorney on that matter. The other thing I'd like to point out about this rule is that this rule does not prohibit or cause represented persons from speaking to one another. So let's say you are representing the wife in a divorce and the husband is being represented by counsel as well. Husband and wife can speak to each other all they want. You just simply can't speak to the husband. You should be speaking to the husband's attorney. But the two represented parties can speak to each other if they so choose. The next rule that I would like to discuss is communications with unrepresented persons. So we just talked about the rule regarding communications with represented persons. Now we're talking about the opposite, how to communicate with someone that is not represented by their own attorney. So first and foremost, in dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that they are disinterested in the matter. So for example, if a lawyer is attempting to settle a matter with an unrepresented person on behalf of a client, the lawyer shouldn't say something like, I want what's best for everyone, because that's not true. And that implies that they're disinterested, and that is not ethically permissible. The rule also goes on to tell us that when the lawyer knows or reasonably should know that that unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall take reasonable efforts to correct this misunderstanding. So this might simply mean that the lawyer wants to constantly remind that unrepresented person that the lawyer is not their lawyer, but in fact representing the opposing party in that action. The rule also says that the lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel. If the lawyer knows or reasonably should know that the interests of such a person are or have the possibility of being in conflict with the interests of the client. A lot of people think that when speaking to an unrepresented person that they have to tell that unrepresented person to seek counsel, and that is not accurate. This rule simply says that we shall not give legal advice to unrepresented persons. And if you're going to give legal advice to these people, you need to make sure that you're advising them to get their own counsel. That wraps up this subsection of the rules here, and we're going to move on to the next part.